You're the intern. The case file hits the desk, not placed, thrown. Pages scatter across polished mahogany. Motion briefs, exhibits, sticky tabs marking deadlines already 2 days overdue. Marcus Holloway freezes mid-step, hands still extended from knocking on the chamber door he'd been told to enter without waiting. Judge Dalton Crew doesn't look up from his computer screen. 58 years old, gray at the temples, reading glasses perched halfway down his nose like a man perpetually annoyed at having to look at anything beneath his station. Yes, Your Honor. Marcus Holloway. I was told to deliver research memo, due yesterday. Where is it? Not a question. Command disguised as inquiry. Marcus pulls the folder from his canvas messenger bag. 22 pages, double-spaced, 67 footnotes. 40 hours condensed into legal analysis of Fourth Amendment search and seizure precedent across 3 circuit courts. He'd spent Saturday in the university library while his roommates drove to Cleveland for a baseball game. Slept 4 hours total between Friday night and Sunday morning. Proofread the document twice, once on screen and once printed, checking every citation against the blue book. Leave it. Crew's hand moves. Dismissive wave. Fingers flicking toward the corner of his desk, like he's shooing a persistent fly. The gesture lasts less than 2 seconds, but carries the weight of 19 years on the federal bench, a lifetime appointment that makes him accountable to no one except the appeals court that rarely overturns him. Marcus sets the folder down carefully, aligned with the desk's edge. Professional. Precise. Everything his mother taught him about presenting yourself in spaces that don't expect you to belong. He turns toward the door. Then he sees it. The trash can beside the judge's desk. Metal, government issue, dented on one side. A manila folder sits on top, visible even from 6 feet away. The tab label is printed in block letters, Williams v. State, motion for new trial. Filed 3 weeks ago according to the docket Marcus reviewed during his first week. Oral argument was scheduled for yesterday afternoon, 2 p.m., courtroom 3. He'd checked the public calendar that morning out of habit, the same way he checks everything, compulsively, obsessively, the habit of someone who learned early that missing details costs you. The folder's spine is unbroken, pages pristine, never opened, never read. Your Honor, the Williams motion. I said leave it. Crew's voice doesn't rise, doesn't need to. The tone carries finality, the kind that comes from 2 decades of people obeying without question. Marcus's hand tightens on the doorknob. The folder sits in the trash like evidence at a crime scene, perfectly visible, completely damning. Defendant Williams is in prison right now, waiting for a ruling on evidence the judge never reviewed. Due process reduced to a checkbox on a form, justice delivered at the speed of administrative convenience. Marcus memorizes the case number, pulls the door shut. The lock clicks twice. Mechanical sound, final. Then silence. If you're wondering how an intern ends up taking on a federal judge, make sure you're subscribed. This story goes places you won't believe. He walks down the hallway. 3rd floor of the U.S. District Court, Southern District of Ohio. Marble floors polished to mirror shine, brass fixtures gleaming under fluorescent lights. Portraits of former judges line the walls, old white men in black robes, expressions severe, guarding the temple of justice like it's theirs by birthright. Marcus passes the clerk's office, the law library, the break room where other interns gather during lunch to trade war stories about difficult assignments and demanding judges. He doesn't stop. Doesn't speak to anyone. Goes directly to the intern workspace, converted conference room on the 2nd floor, 12 desks crammed together, law students from Ohio State, Michigan, Northwestern. Marcus's desk is in the back corner, farthest from the window, the spot nobody wanted. He'd arrived last on the first day, 20 minutes early, but still last because everyone else had shown up 30 minutes early, staking their territorial claims. He sits, opens his notebook. Black moleskin, college graduation gift from his mother 3 months ago. Document everything, she'd written on the first page in her careful handwriting. Nobody remembers to give credit. You have to keep the receipts yourself. Marcus writes, July 23, 2018, 4:47 p.m. Judge's chambers. Williams, Vrison state case file in trash. Motion for new trial, unread. Oral argument scheduled same day. No transcript, no ruling on docket as of 4:30 p.m. Case number 315 CR 000847. He writes the facts. Just the facts. No interpretation, no emotion, nothing that could be called exaggeration later when someone, if someone, ever asks. First-generation college graduate, first in his family to finish high school without needing to work full-time, first to imagine that law school was possible instead of fantasy. He learned early. Documentation is survival. Proof matters more than truth when the system decides who gets believed. Still writing your novel? Kevin Chen leans against the partition separating Marcus's desk from the main workspace. 24 years old, Ohio State Law 2L, already has a job offer from a corporate firm in Chicago. His internship is resume decoration, networking opportunity, the kind of credential that looks good on LinkedIn. Marcus's internship is different. It's the only line on his resume that says he's worked inside the federal court system, the only thing that might convince a law school admissions committee he belongs. Just reviewing procedure. Kevin glances at the notebook, sees the dense handwriting, the case citations, the timestamps. For an internship? Man, you take this way too seriously. It's June. Enjoy the summer. Marcus doesn't answer. Closes the notebook. Kevin shrugs and walks away, back to his desk where he's scrolling through his phone, probably texting friends about weekend plans. The other interns do this too. Treat the position like a formality, a box to check. 8 weeks of showing up and going through motions before returning to real life. None of them need this the way Marcus needs it. None of them are carrying student loan debt equal to a mortgage. None of them are one bad recommendation letter away from watching their future collapse. He reopens the notebook, adds one more line. Judge never acknowledged my presence, referred to me as the intern without using name. Small detail, maybe meaningless, or maybe part of a pattern Marcus doesn't fully see yet. His phone buzzes, text from his roommate, Tigers 1-7-3. You missed a great game. Marcus doesn't respond. He has another research assignment due Friday, 50 cases to analyze, summary brief, expected to synthesize 3 decades of qualified immunity doctrine across multiple circuits. 50 cases equals roughly 1,400 pages of legal opinions. Other interns got 15 case assignments with week-long deadlines. Marcus got 50 cases with a 72-hour turnaround. He opens his laptop, logs into Westlaw, starts reading. The library stays open until 9. He'll be here that long, probably longer. 3 weeks earlier, June 4th, orientation day. Marcus had arrived at the courthouse at 7:30 a.m. for an 8 o'clock start. The security line was already forming, attorneys in suits, clerks in business casual, visitors clutching paperwork for hearings. He'd gone through the metal detector, placed his bag on the conveyor belt, waited while the guard examined his intern badge with the kind of scrutiny usually reserved for counterfeit currency. First day? The guard was older, black, name tag reading Williams, no relation to the defendant, whose file would end up in the trash 3 weeks later. Just coincidence, the kind that makes you wonder if names carry weight or if the universe just has a limited imagination. Yes, sir. You'll do fine. Keep your head down, work hard, don't make waves. Advice delivered like benediction. Marcus had nodded, collected his bag, taken the elevator to the 4th floor where orientation was held in the main conference room. 12 interns total. He'd counted. Compulsive habit, always counting, always measuring, always calculating odds. 11 white faces, 1 black. 11 students from schools with names that open doors. Michigan, Northwestern, Georgetown. 1 student from Bowling Green State University who'd transferred to Ohio State for the name recognition, who'd worked 3 jobs to pay tuition, who'd graduated summa cum laude because anything less would have meant failure. The court administrator had led orientation. Vivienne Shaw, 54 years old, 30 years in federal court administration, the kind of institutional knowledge that makes her indispensable and untouchable. She'd gone through the checklist, dress code, security protocols, confidentiality agreements, break room etiquette. Her voice had the practiced cadence of someone who'd given this speech 100 times, adjusting nothing year after year because the script worked and changing it would require effort. Assignments are posted on the bulletin board outside. You've each been placed with a specific judge's chambers. This is an observational position. You're here to learn, not to practice law. You assist with research, filing, administrative tasks. You do not give legal advice. You do not speak to litigants. You do not discuss cases outside the courthouse. She'd paused, made eye contact with each intern, except Marcus. Her gaze had skipped over him like he was furniture, something to be catalogued and dismissed in the same glance. Remember, judges are busy. They're handling dozens of cases simultaneously. Your job is to make their work easier, not harder. Stay professional. Don't ask unnecessary questions. If you have concerns, bring them to me first, never directly to the judge. Marcus had written it all down, every instruction, every protocol. While other interns took photos of the bulletin board with their phones, Marcus had copied the information by hand, ink on paper, permanent record. His assignment? Holloway M. Chambers of Honorable Dalton Crew, room 312. He'd researched Judge Crew that night. Online biography, published opinions, news coverage. Yale Law School, graduated 1984. Federal prosecutor for 8 years. Private practice at a white shoe firm for 6. Appointed to the bench in 1999 by a Republican president, confirmed by a Republican Senate, lifetime tenure granted at age 38. Young for a federal judge. Ambitious. The kind of appointment that suggests someone was being groomed for higher office, maybe appellate court, maybe Supreme Court if the political winds shifted right. Marcus had read 20 of Crew's published opinions, noticed patterns. Terse writing, minimal analysis, frequent reliance on procedural dismissals rather than substantive rulings, citations to circuit precedent, but rarely to district court colleagues, as if acknowledging other judges' reasoning would diminish his own authority. Dissents from appellate reversals that read defensive, almost petulant, arguing that his original ruling was correct and the circuit court was overreaching. Red flags. Small ones, the kind that only matter if you're looking for them. Marcus had showed up Monday morning at 8 a.m. sharp, knocked on the chamber's door, waited, knocked again. Finally, Preston Gaines had opened it. Senior law clerk, 35 years old, Yale law graduate who'd clerked for a Sixth Circuit judge before taking this position. Gaines was tall, angular, the kind of thin that comes from nervous energy rather than discipline. His suit was expensive, Brooks Brothers probably, and his tie was knotted with the precision of someone who cares about these things. "You're the intern." Same words Judge Crew would use 3 weeks later, delivered with the same tone. Acknowledgement without welcome, identification without interest. "Yes, Marcus Holloway." "I'm Preston. I run the chambers. Judge Crew is in court until 11. You'll organize the appellate briefs in the storage room, alphabetically by case name. After that, there's filing that needs to be done. Questions?" "No, sir." "Don't call me sir. Just Preston." Marcus had spent that first day in a windowless storage room sorting briefs that were already mostly sorted, the kind of make-work assignment designed to keep interns occupied and out of the way. He'd worked carefully, checking each label, ensuring perfect alphabetization, because doing less would have been failure, and failure wasn't an option. Around noon, Claudette Raines, courtroom deputy, 48 years old, 15 years in Crew's chambers, had brought him a stack of documents to file in the clerk's office downstairs. "Welcome aboard," she'd said. Voice neutral, expression carefully blank. "You need anything, just ask." She'd left before Marcus could respond. He would see her every day for the next 8 weeks, watch her process paperwork with mechanical efficiency, witness her presence at every hearing and conference and meeting. She would see everything, hear everything, say nothing. That first week established the pattern. Marcus arrived early, 7:45 a.m., and stayed late, 6 p.m., sometimes 7. Other interns worked 9 to 5, took long lunches, treated the position like the formality it was supposed to be. Marcus worked like someone proving his right to exist in the space. He completed every assignment, met every deadline, asked no unnecessary questions, made himself useful in the hope that useful would translate to valued. Judge Crew barely acknowledged his existence. Monday, Marcus delivered case files to the judge's desk. Crew had been on the phone, waved vaguely toward the corner without looking up. After the call ended, Crew had addressed Preston. When the intern arrives, have him organize the appellate briefs by filing date. Marcus had been standing 3 feet away, plainly visible, already present. Crew had looked through him like he was glass. Tuesday, calendar call, in courtroom 3. Marcus had sat in the back row of the gallery, observing the procedural dance of docket management, lawyers announcing appearances, judges confirming hearing dates, clerks noting continuances. During roll call of court staff, Judge Crew had read from a list: law clerks Preston Gaines and Jennifer Okoro, courtroom deputy Claudette Rains, intern Marcus, Hollywood. Laughter from the attorneys in the gallery. Not cruel laughter, just automatic, the nervous social response to a judge's joke, whether or not it was actually funny. Marcus had cleared his throat softly. Holloway, Your Honor. Crew hadn't acknowledged the correction. Thursday's calendar call, he'd used the wrong name again. Hollywood became a running joke, small and stupid and corrosive. Preston started using it too, then Jennifer. Then the attorneys who were regulars in Crew's courtroom, the defense lawyers and prosecutors who knew that keeping the judge in a good mood was worth more than a stranger's dignity. Wednesday, research assignment. Analyze Fourth Amendment search and seizure precedent, summarize key holdings across circuits, identify any splits in authority. Judge Crew had handed Marcus a list of 50 cases: Terry v. Ohio, United States versus Mendenhall, Florida versus Royer, 47 more spanning 6 decades of constitutional law. The list kept going, case after case, each requiring careful reading and synthesis. Summary by Friday. 50 cases meant approximately 1,400 pages of legal opinions, assuming average length. Reading, analyzing, and synthesizing that volume in 3 days was objectively unreasonable, the kind of assignment designed either to test limits or to engineer failure. Marcus had checked with the other interns over lunch. Jessica Ortiz, Northwestern Law, Chambers of Judge Brennan, 15 cases, week-long deadline. David Park, Michigan Law, Chambers of Judge Matsumoto, 20 cases, 10 days. Marcus, 50 cases, 72 hours. He'd worked through Wednesday night, Thursday all day. Friday morning he'd submitted 18 pages of analysis, organized by circuit, annotated with relevant distinctions, footnoted extensively. Professional quality work compressed into an impossible timeline. Judge Crew had accepted the memo without comment, set it aside without reading it, moved on to the next item on his agenda. No feedback, no acknowledgement, nothing. Marcus had learned something that first week. Invisibility could be weaponized. Being ignored was its own form of violence, surgical and clean, leaving no marks anyone else could see. Second week, Monday morning. Marcus arrived at Chambers to find a note on his desk, handwritten on the judge's official stationery, precise block letters. Deliver oral argument bench brief for Patterson suppression hearing. Courtroom 3, 10:30 a.m. The time on the note, 10:15 a.m. 15 minutes to locate the brief, get to the courtroom, deliver it before the hearing started. Marcus had searched Preston's desk, drawer after drawer, organized chaos of pending matters and research materials. Found the brief at 10:22. Ran down 2 flights of stairs because waiting for the elevator would have cost time he didn't have. Arrived at courtroom 3 at 10:28, breathing hard, sweat soaking through his shirt collar. Judge Crew had been at the bench already, robed, reviewing notes. Marcus had approached the clerk's station, handed Claudette the brief. She'd glanced at it, then at him, expression flickering with something that might have been sympathy before resetting to professional neutrality. This was due at 10. I just received. The judge needed this 30 minutes ago. Marcus had opened his mouth to explain. The note said 10:15, physically impossible to deliver it earlier. But Crew had looked up from the bench, made eye contact. First time all week he'd actually looked directly at Marcus rather than through him. "Is there a problem, Mr. Hollywood?" The courtroom had gone silent. Attorneys at counsel tables, court reporter at her station, bailiff by the door, everyone watching. Marcus had felt his face flush hot, then cold, the particular shame of being called out in public for failing at a task designed to be impossible. "No, Your Honor." "Then take your seat." He'd sat in the back row, watched the hearing proceed. Judge Crew had ruled from the bench without referencing the brief Marcus had delivered late, the brief that apparently wasn't needed at all, the whole exercise a test of some kind, or maybe just casual cruelty, the kind that people with power inflict because they can and because nobody stops them. After the hearing, Preston had pulled Marcus aside in the hallway. "Word of advice. Judge doesn't like interns who make excuses. You were late, you apologized, move on. Don't try to explain. Makes it worse." The note said, "Doesn't matter what the note said. What matters is the judge's expectation. You're here to learn how the system works. First lesson? The judge is always right, even when he's wrong. Especially then." Preston had walked away. Marcus had stood in the hallway, marble floor cold through his shoes, portrait of some dead judge staring down from the wall with the expression of a man who'd never been questioned in his life. That afternoon, Judge Crew had called Marcus into chambers. Rare event. Usually, assignments came through Preston or were left in notes. Being summoned felt significant, though Marcus couldn't tell if that significance was positive or negative. He'd knocked, waited for permission, entered when called. Crew had been at his desk, reading glasses on, reviewing a brief. He'd let Marcus stand there for 45 seconds without acknowledging him. Marcus had counted, another compulsive habit, the way prey animals count heartbeats between predator movements. Finally, "Your Fourth Amendment memo." Marcus's chest had tightened. The 18 pages he'd worked 70 hours to produce, handed in Friday, sitting on Crew's desk now with sticky notes in the margins. Red ink. Lots of red ink. "Yes, Your Honor?" Inadequate. One word, delivered flatly, no elaboration. "I'm happy to revise." "I asked for 50 cases. You analyzed 48. Marcus's mind had raced. He'd checked the list 3 times, counted the cases, 50 exactly, unless— "Your Honor, I analyzed all 50 cases on the list. The list was illustrative, not comprehensive. When I say analyze Fourth Amendment precedent, I mean comprehensive analysis, not just the cases I spoon-feed you." The rules had changed mid-game. The assignment had been impossible, then Marcus had made it possible through inhuman effort, so now the terms were being rewritten to make it impossible again. This was the game. This was always the game. Move the goalposts, change the standards, ensure failure regardless of effort. "I apologize, Your Honor. I'll revise." "Don't apologize. Do better." Crew had picked up the memo, held it over the trash can, the same government-issue metal trash can where the Williams file would appear 3 weeks later. Held it there for 3 seconds, long enough for Marcus to understand what was about to happen. Then dropped it. 18 pages. 70 hours of work. Fluttered down into the trash like confetti, like it had never mattered. Like Marcus's time and effort and desperate need to prove himself worthy were all equally disposable. Redo it. Comprehensive analysis. Friday. Today was Monday. That gave Marcus 4 days to redo work that had taken 3 days the first time, except now the assignment was even more expansive, comprehensive, whatever that meant, no clear parameters, standards that would shift again the moment he met them. "Your Honor, I have another assignment due Thursday for—" "Then I suggest you manage your time better." Dismissal. Hand wave. Marcus had left the chambers, closed the door carefully, walked to the intern workspace with his face frozen in neutral expression because showing emotion was weakness, and weakness was blood in the water. He'd sat at his desk, opened his notebook, written the date, the time, Verbatim quotes as close as he could remember them. Documentation. Evidence. Proof of something, though he didn't yet know what. Jessica Ortiz had come by around 5 p.m., saw him still at his desk, surrounded by open books and printed cases. "You're still here?" "Assignment due Friday." "Which judge?" "Crew." Her expression had shifted. Something like recognition, maybe sympathy. She'd pulled over a chair, sat down uninvited. "How bad is it?" 50-case memo. Threw the first version in the trash. Wants comprehensive revision. Jesus, how are you supposed to... She'd stopped herself. Changed track. "Other interns are saying he's rough on you specifically. Like more than normal rough." Marcus had closed his notebook. "I can handle it." "You shouldn't have to handle it." She'd leaned forward, lowered her voice even though they were alone. Last year, an intern in Crew's chambers filed a complaint about workload, about treatment. Nothing happened. Court administration closed it as coaching provided. The intern didn't get a recommendation letter, couldn't get into any law schools. Last I heard, she's working retail. The story had settled into Marcus's chest like lead weight. Confirmation of what he'd suspected. This wasn't about his performance. This was about power. This was about a judge who'd learned that he could destroy interns' futures with impunity, that the system would protect him and abandon them, that complaints went nowhere except into files marked resolved. "I appreciate the warning," Marcus had said. Voice steady, betraying nothing. Jessica had studied his face. "You're not going to file a complaint, are you?" "No." "Good. Don't. Just survive the summer, get your letter, get out." She'd left. Marcus had stayed until 9 p.m., working through cases, taking notes, building the comprehensive analysis that would probably end up in the trash, too. He'd caught the last bus home, walked 4 blocks to his apartment, microwaved instant ramen, ate it standing over the sink. His roommates had been out. Monday night, summer in Columbus, bars and restaurants, and normal 22-year-old life happening somewhere Marcus couldn't afford to participate in. He'd opened his notebook, added Jessica's story to his documentation, not because he planned to do anything with it, just because forgetting felt dangerous. Week 3. The pattern solidified. Judge Crew's treatment of Marcus moved from dismissive to hostile, from passive cruelty to active punishment. The impossible deadlines continued. 20-page memo due in 36 hours, research assignment requiring analysis of 50 years of civil procedure precedent with 48-hour turnaround. Marcus met them all. Worked 80-hour weeks, slept in the courthouse law library, survived on vending machine food and coffee that tasted like battery acid. He met every deadline, every single one, and every single assignment came back marked inadequate, incomplete, missing some unstated requirement that Crew invented after the fact to justify rejection. Thursday morning, calendar call. Marcus had been sitting in the gallery, observing as required. Judge Crew had called a brief recess, asked the courtroom deputy to summon all chamber staff. Preston and Jennifer had come from the back room. Claudette had stood from her desk. Marcus had approached the bench, unsure if chamber staff included interns, but unwilling to assume otherwise. Crew had looked directly at him for the first time in days. "Mr. Holloway." Not Hollywood, his actual name. Marcus had felt a flicker of hope. Maybe this was the turn. Maybe the hazing was ending. Maybe he'd finally done enough work to earn basic respect. "Yes, Your Honor." "Stand up." Marcus had already been standing. He'd straightened further anyway, spine rigid, hands at his sides. "I'd like to address intern performance." Crew's voice had carried through the courtroom. Attorneys at counsel tables, clerk at her station, court reporter with hands poised over keys. Audience assembled. "Mr. Holloway submitted a research memo this week. The assignment was 50 pages due Thursday. He submitted 43 pages. False. Marcus had submitted 52 pages. He'd counted twice. But correcting a federal judge in open court was career suicide, so he'd stood silent while the lie hung in the air. When asked to correct this deficiency, he complained about workload. Also false. He'd said nothing about workload. Had accepted the revision assignment without protest. But again, correction impossible, defense futile. In my chambers, we don't make excuses. We meet expectations. This is the federal judiciary. Standards exist for a reason. If you can't meet them— Crew had paused for effect. Then perhaps you're not suited for this profession. The threat had been explicit. Clear. Your future depends on me, and I'm deciding right now whether you have one. Marcus had felt every eye in the courtroom on him, felt the weight of judgment from strangers who didn't know him, didn't care about him, would forget this moment within an hour while he'd carry it forever. You may sit down. Marcus had returned to his seat. The hearing had resumed. Life continued as if nothing had happened, except Marcus's hands were shaking and he couldn't make them stop. Lunch break, he'd gone to the courthouse bathroom, locked himself in a stall, sat on the closed toilet lid and breathed carefully, counting inhales and exhales, 4 counts in, hold 4 counts out. The breathing exercise his mother had taught him when he was 12, and kids at school were calling him names he wouldn't repeat even in memory. He'd pulled out his phone. Almost called her, almost. Put the phone away. She was working. 2 jobs, both retail, barely making rent on the house where Marcus had grown up. She'd sacrificed everything to get him through college, taken overtime shifts and skipped meals and worn shoes with holes in the soles, so Marcus could have new ones for job interviews. He wasn't going to call her now and admit he was failing, wasn't going to make her worry, wasn't going to add his problems to the weight she already carried. Instead, he'd opened his notebook app, typed July 19, 2018, public humiliation in open court, false statements, page count and complaints, threat regarding professional suitability, witnesses, approx, 15 attorneys, court staff, other interns, documentation, the only power he had. That afternoon, Preston had stopped by Marcus's desk. That was rough in there. I'll survive. Look, I'm going to give you some real talk. Judge Crew has his way of doing things. He's been on the bench 19 years. He knows what he's looking for. If he's riding you this hard, it's because he sees potential, but needs to know you can handle pressure. The words were meant to comfort. They didn't. Because Marcus could read subtext, could hear what Preston wasn't saying. This is normal. This is fine. Accept it. I appreciate the perspective, Marcus had said. Neutral. Careful. Preston had hesitated. You know, most interns who struggle in Crew's chambers, they don't finish the summer. They find reasons to leave early. Medical issues, family emergencies, whatever. No shame in it. Translation: quit. Make it easy for everyone. I'm not leaving, Marcus had said. Preston had shrugged. Your call. He'd walked away, leaving Marcus alone with the knowledge that the system had a pattern, an escape hatch built in for interns who couldn't take the abuse. Leave early, withdraw quietly, let the judge maintain his reputation while you absorb the failure. The perfect mechanism for ensuring nobody ever accumulated enough evidence to matter. Marcus opened his notebook, wrote down Preston's comments verbatim, added them to the growing record of small cruelties and institutional indifference. He would not quit, would not leave, would finish this summer if it killed him, would get his completion certificate, would document every single violation until he had enough evidence to what? File a complaint that would be buried, report to court administration that was invested in protecting judges, appeal to Dr. Lorna Pierce, the intern program director who'd given that orientation speech about not making waves? Marcus didn't know yet, but he knew documentation mattered, knew that someday, somehow, there would be a moment when this evidence would be useful. He just had to survive until then. Friday afternoon. Marcus submitted the revised Fourth Amendment memo, 58 pages, comprehensive analysis spanning 70 years of precedent, organized by circuit with cross-references to district court applications. He'd worked 90 hours that week. His eyes burned. His back ached from hunching over library tables. He'd lost 6 pounds because he kept forgetting to eat. Judge Crew accepted the memo without comment, set it aside without reading it, handed Marcus a new assignment. Qualified immunity analysis. 50-page memo, due Tuesday. 4 days. Weekend included. July 21st to July 24th. Marcus took the assignment sheet. Didn't argue. Didn't protest. Just nodded and left the chambers and went back to his desk and opened his laptop and started reading. Saturday. He worked in the library from opening to closing. 8 a.m. to 9 p.m. Sunday. Same schedule. Monday. He came in at 6 a.m., worked until midnight. Tuesday morning, he submitted 47 pages, 3 pages short, not because he couldn't write them, but because his body had literally stopped functioning, hands cramping, vision blurring, words on the screen swimming like fish. Tuesday afternoon, called to chambers. Judge Crew held the memo over the trash can, didn't even pretend to read it first. Just held it there, making eye contact with Marcus, ensuring he watched. 47 pages. I asked for 50. Yes, Your Honor. I prioritized the most relevant. The memo dropped. Pages fluttered down. 47 pages of work, 100+ hours of research, gone. Redo it. 50 pages minimum. Tomorrow. Tomorrow was Wednesday. That meant tonight. All night, no sleep, mechanical extraction of 3 more pages from a brain that had nothing left to give. Your Honor, That's all. Dismissed. Door closing. Marcus standing in the hallway with his hands shaking again, rage building in his chest like magma, hot and molten and dangerous. He walked to the bathroom, ran cold water over his wrists, looked at his reflection in the mirror. 22 years old, looking 40, dark circles under his eyes, weight dropping off his frame. He thought about Preston's words. Most interns who struggle, they don't finish the summer. He thought about the intern Jessica had mentioned, the one who'd filed a complaint and had her life destroyed. He thought about his mother working double shifts so he could be here suffering like this for free, for the privilege of being publicly humiliated and privately ground down. He pulled out his phone, opened his notebook app, documented everything, the page count, the repeated disposal of work, the impossible deadline, added it to the timeline he was building. 3 weeks of entries now, dense documentation, the kind of evidence that would matter if anyone ever cared enough to look at it. Then he went back to his desk, opened the qualified immunity memo, found 3 more pages worth of analysis somewhere in his exhausted brain, stayed until 3 a.m., slept 2 hours with his head on the desk, woke at 5, finished the last paragraph, submitted at 8 a.m., Wednesday morning, 51 pages, 1 page over minimum. Perfect compliance. Judge Crew barely glanced at it, set it aside with all the others. Marcus never learned if he actually read any of them, or if the assignments existed purely to inflict suffering. That afternoon, calendar call. Marcus sat in the gallery. Judge Crew handled motion practice, attorney arguments, bench rulings, procedural decisions. One case stood out. Mitchell Lang defending a motion to suppress evidence in a drug trafficking case. Lang was a regular in Crew's courtroom, 40s, expensive suit, practiced confidence of someone who knew the game. Lang had started his argument. Your Honor, the search violated my client's Fourth Amendment rights under Rodriguez v. United States. Counsel. Crew had interrupted 30 seconds in. I've read your brief. Motion denied. Your Honor, if I may just address the... You may not. The search was constitutional. Exigent circumstances clearly established. Motion denied. Next case. Lang had sat down, smiled. A small smile, knowing smile, the kind that suggested he'd gotten exactly what he wanted. He'd glanced back at the gallery, made eye contact with Marcus for just a second, and winked. After court, Marcus had passed Lang in the hallway. First internship, kid? Yes, sir. Word of advice. Lang had lowered his voice. Judge Crew's got a system. Fast rulings, minimal argument, Everything stays efficient. Works for everyone. Prosecutors get their convictions. Defense attorneys preserve appealable issues. Judge keeps his docket moving. Don't mess with it. The implications had been clear. Lang knew Crew didn't actually read briefs. Knew rulings were perfunctory. Knew the whole thing was theater. Justice reduced to assembly line processing. And Lang was fine with it. Benefited from it. Exploited it for his clients. "Understood," Marcus had said. Lang had patted his shoulder. "You'll do fine. Just keep your head down, don't make waves, get your recommendation letter. That's all this is really about, right?" The letter. He'd walked away. Marcus had stood in the hallway, watching him go, understanding now that the corruption wasn't one man. It was a system. Judges who didn't read briefs. Attorneys who knew and didn't care. Court staff who witnessed and stayed silent. Interns who were crushed and warned not to complain. Everyone complicit, everyone protected, everyone benefiting except the defendants whose lives were being processed like paperwork. Marcus had opened his notebook, added Lang's name, added the case citation, added the quote about the system. He didn't know yet what he'd do with this information, but he was building something, a case, evidence, proof that would matter when the moment came. 3 weeks of hell, but also 3 weeks of documentation. 3 weeks of watching and learning and writing everything down. The summer was only half over. This is just the beginning. The confrontation gets so much more intense. Stay tuned to see how Marcus fights back. Week 4 began with the Williams file in the trash. July 23rd, the moment that crystallized everything Marcus had witnessed into something undeniable. Not interpretation, not perception, not the subjective experience of feeling dismissed. Physical evidence. A case file discarded without review. A defendant's rights treated as inconvenient paperwork. Marcus had documented it immediately. Case number, timestamp, observation details. Then he'd researched. Pulled the Williams docket from Pacer that night after leaving the courthouse. Found the motion for new trial. Read the arguments. Newly discovered evidence. Alibi witness who'd come forward 6 months after trial. Surveillance footage that the original defense attorney had missed. Good evidence. Compelling evidence. The kind that should have generated at least a hearing, at minimum an opportunity for the defendant to present his case. Instead, denied by minute order. 2 sentences. Motion for new trial denied. Defendant failed to establish sufficient cause for relief. Filed at 4:52 p.m. on July 23rd, 4 minutes after Marcus had left chambers, 4 minutes after seeing the unopened file in the trash. The timeline was damning. Judge Crew had ruled on a motion without reading the brief, without holding the scheduled hearing, without giving the defendant any opportunity to be heard. Due process reduced to checkbox exercise, constitutional rights dismissed as efficiently as one empties a trash can. Marcus had written it all down, every detail. Then he'd lain awake that night, staring at the ceiling of his cramped apartment, thinking about Terrence Williams sitting in prison somewhere, waiting for a ruling that had been predetermined before his lawyer even filed the motion. The next morning, Marcus had made a decision. He would report this. Through proper channels, the way you're supposed to when you witness judicial misconduct. He would go to Dr. Lorna Pierce, the intern program director, and present his documentation calmly and professionally. Thursday, July 26th. Dr. Pierce held monthly office hours at the courthouse for any intern who needed guidance. Marcus had signed up for a 15-minute slot at 2 p.m. He'd spent lunch preparing, organized his notes, rehearsed his presentation, anticipated counter-arguments. He wasn't coming with complaints or emotions. He was coming with evidence. Dr. Pierce's temporary office was a converted conference room on the 4th floor. She'd been there when Marcus arrived. 50 years old, Howard Law graduate, veteran of civil rights litigation before transitioning to academia. She wore her professionalism like armor, tailored suit, natural hair in an elegant twist, reading glasses on a silver chain. She looked like someone who would care about justice, someone who would take misconduct seriously. "Marcus?" She gestured to the chair across from her. Everything okay with Judge Crew's chambers? He'd sat, set his notebook on the table, opened to the Williams entry. I need to report a concern about case handling procedure. Her expression had shifted, not closed exactly, but cautious. The look of someone receiving information they'd rather not hear. Go on, Marcus had explained. The trash can, the unopened motion, the denied hearing, the timing of the ruling. He'd kept his voice steady, professional, presenting facts without editorializing. Dr. Pierce had listened. When he finished, she'd removed her glasses, set them carefully on the table. Did you witness Judge Crew explicitly state he didn't read the motion? No, but the file was unopened and... Then you're making an inference. Her voice gentle but firm. Judges have discretion on oral arguments. Maybe he read the motion earlier, decided no hearing was necessary. The spine wasn't creased. The pages... Marcus. She'd leaned forward. You're 6 weeks into your legal career. Judge Crew has 19 years on the bench. I'm not saying your observation is wrong. I'm saying be very careful before you accuse a federal judge of misconduct based on a folder in a trash can. The words had landed like physical blows, because she was right, technically. He had no definitive proof, just circumstantial evidence. Strong circumstantial evidence, but not enough to meet the burden of proof for a formal complaint. What would count as sufficient evidence? He'd asked. Explicit violation, documentation of the judge stating he didn't review materials, pattern across multiple cases. Right now, you have one observation that could have innocent explanations. What if there are other cases? Then document them. Quietly. Don't make accusations until you have irrefutable proof. She'd paused. And Marcus? Even with proof, think carefully about the consequences. Judges have institutional protection. Interns don't. If you pursue this, you risk your recommendation letter, your law school applications, your entire career. Is one case worth that? He'd sat there, absorbing the message beneath the warning. The system protected judges. The system sacrificed interns. If you tried to fight, you'd lose everything, and nothing would change. If I see something truly egregious, he'd said carefully, explicitly unethical, what's the proper reporting channel? Judicial Conduct Commission. But understand, they receive hundreds of complaints annually. Most get dismissed. The bar for sustaining a complaint against a sitting federal judge is extremely high. They're looking for clear violations of the code of conduct, not judgment calls on case management. She'd handed him her business card. My office number. If you see something that meets that threshold, evidence tampering, explicit bias, criminal conduct, call me. But picking through trash and inferring negligence, that's not a fight you're equipped for yet. The meeting had ended. Marcus had thanked her professionally, walked out with his documentation still in his notebook, his complaint unvoiced, his evidence unexamined. He'd passed Vivian Shaw's office on the way back to chambers. She'd been visible through the glass door, on the phone, and she'd seen him, made eye contact. Her expression had conveyed a clear message. I know where you were. I know what you discussed. I'm watching. Court administration. Administrative oversight of interns. Vivian Shaw controlled recommendation letters, evaluation forms, all the bureaucratic mechanisms that determined whether Marcus's summer counted for anything. And she knew he'd gone to Dr. Pierce with concerns. That afternoon, Preston had stopped by Marcus's desk. How was your meeting with Dr. Pierce? Word traveled fast, too fast. Fine, just career advice. Preston had studied his face. If you're having issues with the judge, you should talk to me first. I can help manage those situations before they become problems. Translation, report through me so I can bury it. Bring concerns to the chamber's clerk who served at the judge's pleasure and had every incentive to protect him. No issues, Marcus had said, just planning next steps after the internship. Good, that's good. Preston had lingered. You know, Judge Crew can be tough, high standards, but he's fair. If you're struggling, it's about the work, not about you personally. Don't take it personally. The gaslighting was almost impressive. Systematic mistreatment reframed as high standards. Abuse recharacterized as fairness. And the implicit threat, complain and you're the problem, not the judge. Marcus had nodded, said nothing, waited for Preston to leave. Then he'd added the conversation to his documentation, noted Vivian Shaw's surveillance, noted the speed with which his meeting with Dr. Pierce had become common knowledge. The message was clear. There was no proper channel, no safe reporting mechanism. The system closed ranks around judges, and interns who complained were marked for destruction. Fine. If formal complaints wouldn't work, Marcus would adapt. He'd document everything, keep gathering evidence, and wait for an opportunity that didn't exist yet. Patience. Strategy. The long game. But that night, lying awake again in his apartment, Marcus had felt something shift inside him. Not defeat. The opposite. Clarity. Understanding. The system wasn't broken. The system worked exactly as designed. It protected power, crushed dissent, ensured that people like Marcus, poor, black, first generation, desperate for the legitimacy that credentials provided, learned their place and stayed there. Fine. He'd learned that lesson. Now he'd spend the rest of his life unlearning it, teaching others to do the same, and building enough power that people like Judge Dalton Crew couldn't crush him anymore. But first, he had to survive the next 4 weeks. Chapter Week 5. The assignments continued, impossible deadlines arriving with metronomic regularity. Marcus met them all, worked 100-hour weeks, stopped going home most nights, just slept in the library with his head on the desk, alarm set for 5 a.m., so he could shower in the courthouse gym before anyone else arrived. His body was failing. His hands shook constantly now, fine tremor he couldn't control. He'd lost 12 pounds. His roommates had stopped inviting him to anything because he never came, was never available, existed in some permanent state of emergency that made normal life impossible. But he was documenting. Every case that went through Crew's courtroom, Marcus watched, took notes, cross-referenced dockets, built a database of rulings that were perfunctory, hearings that were skipped, motions denied without apparent review. Patterns emerged. Judge Crew had a type. Defendants without resources, cases without media attention, motions filed by overworked public defenders who didn't have time to appeal. The victims of his negligence were systematically the people least able to fight back. Want to know how this ends? Subscribe so you don't miss part 2. You won't believe where this goes. Friday, August 3rd. Calendar call. Marcus in the gallery as usual. A case came up. United States versus Patterson. Fourth Amendment suppression motion. Defense attorney argued that evidence seized during a traffic stop violated constitutional protections. The attorney had filed a 40-page brief. Marcus had seen it in the court filing system, had noted the timestamp, filed August 2nd at 4:45 p.m. The hearing was scheduled for August 3rd at 10:30 a.m. But at 10:04 a.m., before the hearing started, Judge Crew issued a minute order. Motion to suppress denied. Officer had reasonable suspicion under Terry v. Ohio. Defendant's Fourth Amendment arguments lack merit. Marcus had checked his watch. 10:04. The hearing was supposed to start at 10:30. The judge had ruled before the hearing occurred. He'd either read a 40-page brief in the 19 hours between filing and ruling, unlikely, or he'd ruled without reading it at all. When the hearing started at 10:30, the defense attorney had looked confused. Your Honor, I see there's already a ruling on the docket. Correct. I reviewed your brief and determined oral argument was unnecessary. The facts are straightforward. Your Honor, with respect, I only filed the brief yesterday afternoon. Are you suggesting I'm incapable of reading a brief overnight, counsel? The attorney had backed down immediately. No, Your Honor, of course not. Then your objection is noted. Motion denied. Next case. Marcus had watched the attorney sit down, frustrated but helpless. Watched Claudette record the ruling without expression. Watched Preston take notes from his seat at counsel table, writing down the judge's words like they were profound instead of fabricated. After court, Marcus had pulled the Patterson docket, printed the timeline, brief filed 4:45 p.m., ruling issued 10:04 a.m., 18 hours, 19 minutes. Physically possible to read 40 pages in that time, but barely, and only if Judge Crew had worked through the night, which Marcus knew he hadn't. Crew left chambers every day at 5 p.m., didn't work weekends, maintained strict boundaries between court and personal life. The ruling was impossible, provably impossible, not inference, mathematical fact. Marcus documented it, added it to the Williams file, to the growing list of cases where procedure was violated, where defendants were denied their constitutional rights, where justice was sacrificed for efficiency. 2 cases now, not enough yet. But getting closer. He needed more evidence. Needed patterns so clear that even the institutional protection couldn't explain it away. Needed documentation so thorough that when the moment came, whatever that moment would be, he'd be ready. He kept working, kept documenting, kept surviving. Week 6, Monday, August 6th. Judge Crew handed Marcus a new assignment during morning meeting. Appellate brief on qualified immunity doctrine. I need a 50-page memo by Thursday. Cover 6th Circuit precedent, every case since 2010. 50 pages. 3 days. 72 hours. 20 hours per day if Marcus didn't sleep, which he couldn't afford to do because he had other assignments pending, because the work never stopped, because stopping meant failure. He tried. Spent Monday pulling cases, reading opinions, organizing notes. Tuesday all-nighter in the library, mainlining coffee and energy drinks, his hands shaking so badly he could barely type. Wednesday, eyes burning, head pounding, extracting analysis from a brain that felt like it was shutting down. Thursday morning, 8 a.m. Marcus had 43 pages, not 50, 7 pages short. He'd written until his body literally stopped responding, words turning to nonsense on the screen, hands cramping into useless claws. He submitted what he had, included a note. Your Honor, additional analysis available upon request. Current memo covers core precedent with focus on circuit splits and recent developments. Professional language. Acknowledging the shortfall. Offering to supplement. Thursday, 10 a.m. Called to chambers. Judge Crew held the memo, didn't open it. Just held it, 43 pages of desperate work, and looked at Marcus with expression of mild disappointment. 43 pages. I asked for 50. Yes, Your Honor. I prioritize the most relevant. When I give a deadline, I expect it met. Crew's voice was calm, conversational, like he was explaining something obvious to someone slow. Not 86% met, not mostly met, fully met. He held the memo over the trash can. Marcus's stomach dropped. Not again. Please, not again. The pages dropped, fluttered down like dying birds. Redo it. 50 pages. Tomorrow morning. Tomorrow. 1 day. To produce 7 more pages from nothing, from exhaustion, from a brain that had already given everything it had. Your Honor, I have another assignment due tomorrow for. Then I suggest you manage your time better, or perhaps. Crew had paused, let the silence stretch. Perhaps this position isn't the right fit for you. The threat was explicit now, not veiled, not implied. Direct statement. Quit, or I'll destroy you. Marcus had stood there, watching his work in the trash, feeling rage build in his chest like pressure behind his eyes. He wanted to scream, wanted to overturn the desk, wanted to grab that trash can and dump it over the judge's head and walk out and never come back. Instead, he said, I'll have it ready tomorrow morning, Your Honor. Voice steady, professional, betraying nothing. He'd left chambers, made it to the bathroom, locked himself in a stall, sat there with his head in his hands, breathing carefully, containing the rage because releasing it meant losing, meant confirming everything they already believed about him, that he was too emotional, too sensitive, not suited for this profession. He stayed there 10 minutes, got himself under control, washed his face, looked in the mirror at the stranger staring back, exhausted, hollow-eyed, barely recognizable. Then he went back to his desk, opened his laptop, started writing. He worked through Thursday night, all night, no sleep, just coffee and determination and spite. Fueled by rage, channeling it into the work, turning it into something productive because productive was the only revenge available. Friday morning, 8 a.m., he submitted 52 pages, 2 pages over minimum. Perfect compliance. Printed and bound, formatted precisely according to federal court standards. Judge Crew barely glanced at it, set it aside with all the others. Marcus never learned if he read it. Suspected he didn't. Suspected the assignments existed purely as punishment, as tools for breaking interns who didn't know their place. That afternoon, Jessica Ortiz found Marcus at his desk, still there at 6 p.m., when everyone else had gone home. "You okay?" "Fine." "You don't look fine. You look like—" She stopped herself. "Like what?" "Like someone who's being destroyed. Deliberately." Marcus closed his laptop, looked at her. She was the only intern who'd shown him any kindness, the only one who'd acknowledged that what was happening wasn't normal. "I'm documenting everything," he said quietly. Jessica's expression shifted. She glanced around the empty office, lowered her voice. "Marcus, you need to be really careful. If they find out I'm not building a complaint, just keeping notes, for my own records." "That's still dangerous. If Crew or Preston or Vivian Shaw finds out, they won't." Jessica sat down, studied his face. "Why are you doing this? Why not just quit? Get out while you can." "Because if I quit, he wins, and someone needs to—" Marcus stopped, reconsidered his words. "Someone needs to document what's happening here, even if nothing comes of it, even if it's just for the record. Someone needs to know." She'd nodded slowly. "You're building evidence for something. Maybe. For what? I don't know yet." And that was true. Marcus didn't have a plan, didn't have a strategy beyond survival. But he had documentation. 3 notebooks now, filling rapidly with case citations and timestamps and verbatim quotes. Evidence of something, even if that something didn't have a name yet. Jessica had stood up. "Be careful, seriously. People who fight the system, they don't usually win." "I know." She'd left. Marcus had stayed until 9 p.m., working on the next assignment, the next impossible deadline, the next test designed for failure, but also adding to his documentation, building the case, preparing for a moment that didn't exist yet, might never exist, but if it ever came, when it came, he'd be ready. 2 weeks left in the internship, 14 days. He could survive 14 days. He had to. Week 7 began with the lowest point. Monday morning, Marcus arrived at Chambers to find his desk had been moved. Not relocated to another spot in the intern workspace, removed entirely. His nameplate, his small pile of reference books, his carefully organized files, all boxed up and waiting in the hallway. Preston had been there, looking apologetic in that performative way people do when they're following orders they know are wrong. "Sorry about this. We need the space for storage. You can work at the table in the file room." The file room was a converted closet. No window, one overhead light, barely room for a table and chair. It smelled like old paper and mildew. The other interns had desks in the open workspace, sunlight, air circulation, proximity to other people. Marcus got a closet. He'd moved his things without comment, set up in the file room, continued working. Claudette had come by around noon, stood in the doorway, looked at the cramped space, shook her head. "This isn't right." First time she'd said anything. First time anyone from Chambers had acknowledged the treatment was wrong. "It's fine," Marcus had said. "It's not fine. She'd stopped herself, glanced over her shoulder, ensuring they were alone. "He's done this before, to other interns. It's his pattern." Marcus had looked up. What happened to them? Most quit. One filed a complaint. It got buried. She didn't get a recommendation letter. Claudette's voice had dropped to barely a whisper. Look, I can't do anything official. I have a mortgage, kids in college. I need this job, but if you're documenting things, I see a lot, hear a lot. If you ever need... She'd trailed off, hadn't finished the offer, couldn't commit to helping, couldn't risk her security, but wanted Marcus to know she witnessed, she knew, she cared, even if she couldn't act. I understand, Marcus had said. Thank you. She'd left. Marcus had sat in his closet office, thinking about patterns, about other interns, about a system that destroyed people systematically and faced no consequences. He'd opened his notebook, added Claudette's comments, added the detail about his desk being moved. The pattern was becoming clearer. Judge Crew did this regularly. Targeted interns, usually the ones who worked hardest, who took the position seriously, who hadn't learned yet that the internship was theater, and broke them, systematically. With institutional support and administrative cover, Marcus was just the latest victim. But maybe he'd be the one who didn't break, who documented instead of quitting, who built evidence instead of accepting defeat. 1 week left, 7 days. He could do this. The final week passed in a blur of exhaustion and determination. Marcus completed every assignment, met every deadline, absorbed every humiliation with the same steady professional composure. He attended every hearing, documented every case, noted every procedural irregularity. By Friday, August 17th, last day of the internship, Marcus had filled 3 notebooks, 400 pages of documentation, case citations, quotes, timestamps, witnesses, evidence of systematic negligence, procedural violations, hostile work environment, abuse of power. He had 11 cases where Judge Crew had ruled without reading briefs, 14 instances where motions were denied without required hearings, 8 examples of defendants denied their constitutional rights, patterns so clear, so overwhelming, that even institutional protection shouldn't be able to explain it away. But he also knew documentation meant nothing without power. Evidence didn't matter if nobody with authority cared to see it. Friday afternoon, Marcus packed his belongings from the file room closet. 3 notebooks, reference materials, the few personal items he'd brought. He said goodbye to Jessica and the other interns who'd survived the summer. Most of them were celebrating, heading to bars, planning weekend trips, relieved to be done. Marcus felt nothing, just exhaustion. He waited for his evaluation meeting with Judge Crew. Standard procedure. Every intern got final feedback, received their completion certificate, discussed the recommendation letter. Marcus's meeting was scheduled for 4 p.m., last slot of the day. He knocked at 4 exactly, waited, entered when called. Judge Crew was at his desk, reviewing paperwork. Let Marcus stand there for a full minute before looking up. Mr. Holloway, congratulations on completing the internship. Thank you, Your Honor. I have your evaluation here. Crew held up a form. Your work was adequate. You met most deadlines. However, I have concerns about your professionalism and your ability to accept constructive criticism. Every word was a lie, but Marcus said nothing, just waited. As such, I've decided to provide a neutral letter noting your dates of service. I cannot in good conscience provide a positive recommendation. The words landed like a death sentence. Neutral letter meant career poison. Every law school, every future employer would see it and wonder what Marcus had done wrong. The letter wouldn't say, neutral meant deliberately vague, but the absence of praise was its own indictment. I understand, Your Honor. I hope you take this as a learning experience. The legal profession requires resilience and the ability to accept feedback without becoming defensive. Work on those qualities, and you may still have a future in law. Gaslighting, complete and polished. Reframing abuse as feedback, destruction as professional development. Marcus took the evaluation form, took his completion certificate, left the chambers. He walked through the courthouse in a daze, documentation heavy in his bag, future suddenly uncertain, years of work and sacrifice potentially wasted because one man had decided Marcus didn't deserve a chance. Outside, the August heat hit him like a wall. He stood on the courthouse steps looking at the building, marble columns, American flag, the words "Equal Justice" under law carved into stone. Lies. All of it. Pretty words carved into expensive stone, covering a system that was designed to protect power and crush anyone who challenged it. Marcus pulled out his phone, called his mother. "Hey, baby, how was your last day?" He'd planned to lie, say it went well, not worry her, but when he heard her voice, everything broke. "He destroyed me, Mom. I did everything right, and he destroyed me anyway." Silence on the other end. Then, "Come home. Take the weekend. We'll figure this out." "There's nothing to figure out. Without a good recommendation letter." Marcus Holloway. Her voice went firm, the tone she'd used when he was young and doubting himself. "Listen to me. You documented everything, right?" "Yes." "Then you didn't lose. You're preparing. This isn't the end. It's just not your time yet. But your time will come, and when it does, you'll have everything you need." She didn't know about the documentation. Marcus had never told her. But mothers know. They always know. What if that moment never comes? It will. Because people like you, people who fight when it costs them everything, you don't do it for nothing. The universe rewards that. Maybe not today, maybe not this year, but eventually, justice finds a way. Marcus didn't believe in the universe, didn't believe in cosmic justice. But he believed in his mother, believed in documentation, believed that somewhere, somehow, there had to be a path forward. "I love you, Mom." "I love you too. Come home. Rest. Then we plan next steps." He hung up. Stood there on the courthouse steps as other people, attorneys, clerks, litigants, filed past him, living their lives, participating in the system that had just chewed Marcus up and spit him out. He thought about quitting, giving up on law school, finding another path, admitting defeat. Then he thought about Terrence Williams, sitting in prison because a judge didn't read his motion. Thought about all the other defendants whose rights were violated because judges like Crew operated with impunity. Thought about future interns who would suffer the same abuse unless someone, someday, held the system accountable. Marcus opened his bag, looked at the 3 notebooks. 400 pages of evidence. Not enough yet. Not enough power to make it matter. But someday, when he had power, when he had a platform, when he couldn't be destroyed by one person's recommendation letter, he'd use this. He'd make it count. He just had to survive until then. Had to get to law school somehow. Had to build enough credibility that people would listen when he spoke. Long game. Years, probably. Maybe decades. But Marcus Holloway had learned patience that summer. Had learned how to endure, how to document, how to wait for the right moment. And when that moment came, Judge Dalton Crew would learn what it felt like to have your life reduced to evidence in someone else's case. Marcus walked down the courthouse steps, carrying his documentation, planning his future. The summer was over. The real work was just beginning. Senator Holloway will be chairing today's confirmation hearing. The words echo through the Russell Senate Office Building hearing room, March 18, 2025. 7 years, 7 months, and 23 days since Marcus walked down those courthouse steps, carrying 3 notebooks and a neutral recommendation letter that nearly ended his legal career before it started. Judge Dalton Crew sits at the witness table, navy suit pressed sharp, red tie knotted with the precision of someone who's testified before Senate committees a dozen times. His resume packet, leather-bound, professionally printed, sits in front of every senator on the dais. Yale Law, 19 years District Court, American Bar Association rating, well qualified. Bipartisan support letters from 37 attorneys, 14 law professors, 6 sitting judges. This should be routine. Federal judges get promoted to appellate courts regularly. The confirmation process is usually perfunctory. A few questions about judicial philosophy, some softballs about commitment to the Constitution, a voice vote, done. Crew's people have told him to expect smooth sailing. The ranking Republican already signaled support. The chairman considers this a courtesy hearing. Crew glances at his notes, sees the schedule. Opening remarks. Chairman Wilcox. Ranking member, Senator Thornton. Home state courtesy, Senator Holloway. He doesn't recognize the name. Holloway. Common enough. Probably some freshman senator doing the minimum required for an Ohio nominee, asking bland questions about case management and judicial temperament before voting yes. The side door opens. Marcus walks in. 7 years older now, suit tailored. Brooks Brothers, the real thing, not thrift store approximation. Confident stride built from 2 years in the Ohio State Legislature and 8 months in the U.S. Senate. He takes his seat at the dais, fourth from the left, nameplate visible to everyone in the room, including the 30 reporters in the press gallery and the C-SPAN cameras broadcasting live. Senator Marcus Holloway, D.O.H., Crew, looks up from his notes, sees the nameplate, sees the face. The blood drains from his cheeks in a wave visible even from the press gallery. His hand, reaching for his water glass, trembles. Just slightly, just enough that the water ripples when he lifts it. He drinks. Sets the glass down carefully. Composes his expression into something neutral, professional, betraying nothing except to the people watching closely enough to see the micro-expressions. Shock, calculation, fear, recognition. Marcus doesn't look at him. Not yet. Opens his folder, thick, tabbed, organized with the obsessive precision of someone who's been preparing for this moment since 2018. Adjusts his microphone. Waits. Chairman Wilcox gavels the hearing to order. This committee will come to order. We're here today to consider the nomination of Judge Dalton Crew to the United States Court of Appeals for the Sixth Circuit. Judge Crew has served with distinction on the district court for 19 years. His record demonstrates commitment to the rule of law and fair administration of justice. Wilcox continues with perfunctory remarks, thanking the nominee, acknowledging his family in the gallery, noting the impressive letters of support. Ranking member Thornton follows with equally bland opening statement, everything proceeding exactly as Crew's people predicted. Then, Senator Holloway, you have 15 minutes for questioning as home state senator. Marcus adjusts his microphone, looks directly at Crew for the first time, makes and holds eye contact. Thank you, Mr. Chairman. Judge Crew, congratulations on your nomination. Crew's throat works. Swallows. Thank you, Senator. You may not remember me. Marcus's voice is calm, conversational, the tone of someone asking about the weather. We've met before, summer of 2018. I was an intern in your chambers. The room goes silent. Every senator leans forward. Press gallery. Typing stops. Even the court reporter's hands pause over her keys for half a second before muscle memory takes over. Crew opens his mouth, closes it, opens it again. Opens it. I have many interns over the years, Senator. I don't recall. You called me Hollywood. Mispronounced my name repeatedly despite corrections. You threw my research memo in the trash. Actually, you threw 3 of my research memos in the trash. And you threatened to withhold my bar recommendation letter when I raised concerns about case procedures. The silence deepens. Becomes something physical, pressing against eardrums. Senator, I don't remember those specific. I'm not here for personal grievance, Judge Crew. Marcus slides a document to the clerk. Mr. Chairman, I'm entering into the record a report compiled by Sixth Circuit appellate staff. Judge Crew's reversal rate, 2019 through 2024. The document distributes to every senator. Crew watches the pages move down the dais like watching a firing squad load their weapons. The circuit average reversal rate is 4.2%. Judge Crew's rate is 14.3%. That's more than triple the average. In the past 5 years, he's been reversed 41 times. The most common reason cited by the appellate court is Marcus reads from the report. Abuse of discretion for failure to conduct required hearings or adequately review submitted evidence. Senator Yates, Republican from Georgia, generally supportive of judicial nominees, interrupts. Senator Holloway, with respect, reversal rates alone don't indicate misconduct. Complex cases generate appeals. Agreed, Senator Yates, which is why I'm also entering appellate court opinions. New documents distribute. Marcus has them tabbed, color-coded, organized by type of violation. The preparation is overwhelming. This isn't a senator asking questions. This is a prosecutor presenting a case. Exhibit A, Williams v. State, July 2018. Motion for new trial based on newly discovered alibi evidence. Judge Crew denied the motion without oral argument. The Sixth Circuit reversed 8 months later. Marcus reads from the appellate opinion, voice steady, professional. The district court's perfunctory denial without hearing violates basic due process. When material facts are disputed and newly discovered evidence is proffered, an evidentiary hearing is mandatory under 28 U.S.C. Section 2255. The district court's failure to hold such hearing constitutes abuse of discretion. He looks up, makes eye contact with Crew again. Mr. Williams spent an additional 8 months in prison because you didn't review his motion. Were you aware of the appellate reversal? Crew's lawyer, Benjamin Marsh, seated directly behind him, leans forward, whispers something. Crew nods, clears his throat. Senator, I handle a high-volume caseload. Not every decision survives appeal. That doesn't indicate. Exhibit B, United States v. Patterson. Marcus pulls another tab. The documents keep coming. He's building something, brick by brick, and everyone in the room can see the structure taking shape. Motion to suppress evidence filed August 2, 2018 at 4:45 p.m., 40-page brief. You issued a ruling denying the motion on August 3 at 10:04 a.m., before the scheduled oral argument at 10:30 a.m. The brief argued Fourth Amendment violations across 12 pages of analysis. Your ruling was 2 sentences. How did you read, analyze, and rule on a 40-page brief in 18 hours when you left chambers at 5 p.m. the previous day? Make sure you're subscribed. The receipts Marcus is about to drop will leave you speechless. Silence. Crew's face has gone from pale to flushed. His lawyer whispers again, more urgently. I reviewed the brief and determined that oral argument was unnecessary given the straightforward facts. You determined a 40-page Fourth Amendment brief presenting 12 distinct arguments was straightforward after reading it in, what, your assessment, maybe 2 hours? That's 20 pages per hour while also handling your regular docket? I work efficiently, Senator. Or you don't work thoroughly. The words hang in the air, not a question, an accusation, delivered calmly with the weight of evidence behind it. Senator Thornton tries to intervene. Senator Holloway, I think we should allow Judge Crew to respond fully before... I'm happy to let him respond, Senator Thornton, but first, let's establish the pattern. Marcus pulls another set of tabs. The folder is thick, easily 200 pages. He's prepared for this moment, the way generals prepare for decisive battles, the way prosecutors prepare for career-making cases. Exhibit C through L. 10 additional cases where you issued rulings before scheduled hearings or within hours of brief filings. Appellate courts reversed 7 of these, citing procedural irregularities or inadequate review. 3 are still pending appeal. He reads case citations, dates, times. The pattern is undeniable, mathematical, the kind of evidence that doesn't require interpretation. Exhibit M. Intern complaint records from 2015 through 2020. New documents. These hit differently. Senators who were looking bored, this was supposed to be routine, sit up straighter. Marcus reads from the first complaint. Voice still steady, but there's something underneath now. Personal weight. Complaint filed June 2015. Quote, Judge Crew assigns interns workload triple that of other chambers. When I requested accommodation for medical appointment, he threatened to withdraw my bar recommendation. The complaint was reviewed by Court Administrator Vivian Shaw and closed with notation. Coaching provided, matter resolved. He looks up. No investigation, no disciplinary action, just coaching. Second complaint. Judge Crew publicly humiliated me in open court for filing error. Other interns witnessed. I requested transfer. Was told no transfers allowed midsummer. Same outcome. Coaching. Closed. Third complaint. Judge Crew discarded case files without review, then ruled on motions. When I raised concerns, I was told to stay in my lane by Chambers clerk. Marcus pauses. Lets that one settle. That complaint was filed July 2018, by me. It was closed by Vivian Shaw with the same notation as all the others. No investigation, no action, just coaching that never happened. The room erupts, reporters typing frantically, senators conferring with aides, Chairman Wilcox banging his gavel for order. Crew's face has gone through shock and into something else. Anger, maybe. Or fear. His lawyer is scribbling notes, preparing objections, but there's nothing to object to. Every document is public record, every citation verified, every complaint filed through proper channels and buried by the system. Senator Holloway. Crew's voice cracks slightly. He clears it, tries again. Senator, these complaints were investigated and found to be without merit. They were closed without investigation. There's a difference. Marcus slides forward another document. This one makes several senators gasp when they read it. Court Administration Memo dated August 2016. From Vivian Shaw to Chief Judge Arthur Bellamy. Subject, Intern Complaint Patterns, Chambers of Honorable Crew. He reads aloud. Third complaint this year from Crew's Chambers. Recommend formal investigation per judicial conduct rules. However, Judge Crew has expressed concerns that investigation would damage district reputation and create chilling effect on judicial efficiency. Advise we resolve through informal coaching. Preserves institutional harmony. Marcus looks up. Chief Judge Bellamy's handwritten response, scanned into the record. Agreed, close file. No further action needed. The words detonate like grenades. Because this isn't just one judge's misconduct anymore. This is institutional cover-up. This is the chief judge of the district knowingly burying complaints to protect reputation. This is the system eating its own integrity to preserve the appearance of functionality. Senator Wilcox leans forward. Senator Holloway, are you saying Chief Judge Bellamy is still serving? Yes, Mr. Chairman. He's currently presiding over the Southern District of Ohio. And this memo, when did you obtain it? It was provided to me by a confidential source 3 weeks ago. I've verified its authenticity through comparison with other court documents. The metadata confirms it was created in August 2016 and stored on court administration servers. Wilcox looks at Ranking Member Thornton. They're both calculating. This hearing just became something much bigger than one judge's promotion. This is systemic failure. This implicates court administration, chief judges, the entire oversight mechanism. Marcus isn't done. He pulls another set of tabs. Mr. Chairman, I'd like to call witnesses. This is irregular. Confirmation hearings don't usually include testimony beyond the nominee. But Wilcox nods, recognizing that this has already departed from normal procedure. Proceed, Senator Holloway. The doors at the back of the hearing room open. 3 people walk in, escorted by Senate staff. The first is a black man, mid-30s, wearing a suit that doesn't quite fit, borrowed probably, or purchased specifically for this occasion. Mr. Terrence Williams, please approach. Terrence Williams walks to the witness table next to Judge Crew. They sit 3 feet apart. Crew won't look at him. Keeps his eyes fixed on the table in front of him. Marcus begins. Mr. Williams, please state your current occupation. I'm a paralegal at Community Legal Services in Columbus, Ohio. His voice is steady despite visible nervousness. And in 2015, you were convicted of armed robbery in federal court, Southern District of Ohio. Judge Crew presiding. Is that correct? Yes, sir. You filed a motion for new trial in July 2018 based on newly discovered evidence. What was that evidence? My mother came forward with hospital records showing I was with her during surgery the day of the robbery. My original defense attorney missed it. The new lawyer filed the motion with the records attached. What happened to that motion? It was denied. Never got a hearing. Judge just wrote 2 sentences saying I didn't establish sufficient cause. Did the judge review the hospital records? My attorney says no, the file was never opened. She could tell from the... He hesitates, looking for the right words. From the way it looked when she got it back. Nobody had read it. Marcus slides forward a photograph. Is this the motion file as your attorney received it after the denial? Yes, sir. See how the spine isn't creased? Pages are still pristine. Nobody opened it. The photograph distributes to senators. Same image Marcus saw in 2018. Pristine file, unused, discarded without review. What happened next? I stayed in prison for 8 more months until the 6th Circuit reversed the denial and ordered a hearing. At the hearing, the prosecution reviewed the hospital records and dropped the charges. I was innocent the whole time. Just needed someone to actually look at the evidence. Marcus lets that settle. Terrence Williams, innocent man, imprisoned unnecessarily, because a judge couldn't be bothered to open a file. How much time did you serve total? 3 years, 4 months. Should have been released after the new evidence came out, but Judge Crew never looked at it, so I sat there 8 more months for nothing. Thank you, Mr. Williams. You may step down. Terrence returns to the gallery. Marcus calls the second witness. Dr. Lorna Pierce. An older black woman approaches. 54 now. Professional presence. Professor credentials that command respect. She's sworn in, takes her seat. Dr. Pierce, you're the director of the Federal Judicial Internship Program for Ohio law schools. Is that correct? Yes, Senator. I've held that position for 12 years. In that capacity, you review intern complaints and provide oversight? That's part of my role, yes. Do you remember reviewing a complaint I filed in July 2018? Dr. Pierce's expression softens, regret, visible and genuine. Yes, Senator. I remember it clearly. What did you advise me? I advised you to... She pauses, chooses her words carefully. I advised you to document quietly and not make accusations without irrefutable proof. I warned you that pursuing a complaint could cost you your recommendation letter and damage your career. Was that good advice? It was pragmatic advice. But no, Senator, it was not good advice. It was the advice that perpetuates systemic problems by prioritizing individual safety over institutional accountability. Her honesty is disarming. Several senators look surprised. Witnesses usually hedge, deflect, protect themselves. Dr. Pierce is doing the opposite. How many interns have filed complaints about Judge Crew's chambers in your tenure? 9 formal complaints. That I know of. Likely more informal concerns that never reached the filing stage. What happened to those 9 complaints? All were reviewed by court administration. All were closed as resolved through coaching. To my knowledge, none resulted in disciplinary action or formal investigation. Did you object to this pattern? Not loudly enough. Her voice carries weight of regret. I raised concerns with Court Administrator Shaw on 3 occasions. I was told that judicial independence required deference to judges' management styles. I was reminded that internship complaints rarely met the threshold for formal Judicial Conduct Commission review. She stops, breathes. I was told to stop making trouble, or my program's funding would be reconsidered. The threat hangs there. Institutional pressure applied to someone trying to do the right thing, silencing dissent through economic coercion. Marcus continues. Did any interns withdraw from the program because of conditions in Judge Crew's chambers? 3 interns over 8 years withdrew midsummer and cited hostile work environment in their exit interviews. 1 intern completed the summer but quit law entirely afterward. She explicitly stated that Judge Crew's treatment made her believe the legal profession wasn't worth pursuing. Did you report this pattern to anyone? I included it in my annual program reports to the Administrative Office of the U.S. Courts. Those reports are supposed to be reviewed by circuit judicial councils. I don't know if any action was taken because I never received feedback. Marcus thanks her. Dr. Pierce steps down, and the third witness approaches. Mr. Ellis Rao. The journalist, late 30s, Columbus Dispatch, 15 years covering federal courts, takes his seat. Professional demeanor, comfortable with being on record. Mr. Rao, you published a series of articles in 2021 and 2022 regarding judicial practices in the Southern District of Ohio. What prompted those articles? I received anonymous packages containing case files and court documents. The materials documented patterns of procedural irregularities, motions denied without hearings, rulings issued before scheduled oral arguments, case files apparently unreviewed before decisions. Did you verify the information? Extensively. Every document was cross-referenced with PACER records, appellate dockets, and courthouse public files. Everything checked out. The pattern was clear and documented entirely through public records. Did you determine the source of the anonymous packages? No. But whoever sent them had intimate knowledge of courthouse procedures and access to case files during specific time periods. My assessment was that it came from someone inside the system, likely an intern, clerk, or attorney who'd witnessed the conduct directly. Marcus doesn't confirm or deny. Lets the implications sit. The hearing room knows, everyone knows, that Marcus was the source. But having a journalist testify to the verification process adds credibility. Did Judge Crew or court administration respond to your articles? Judge Crew issued a written statement defending his case management practices and claiming the articles mischaracterized normal judicial efficiency. Court administration declined to comment. Chief Judge Bellamy issued a brief statement supporting Judge Crew and calling the articles unfairly critical of a dedicated public servant. Did the Sixth Circuit Judicial Council open an investigation? They opened a preliminary inquiry in January 2022. It resulted in no disciplinary action. The inquiry was closed with notation that Judge Crew had been advised on best practices for case management. More coaching. More closure without accountability. The pattern repeating at every level. Marcus thanks Ellis. All three witnesses sit in the front row of the gallery now. Living evidence, human impact, the consequences of judicial negligence made flesh. Marcus turns back to Judge Crew. Judge Crew, you've sat here for 40 minutes listening to testimony about your conduct. Do you dispute any of the specific facts presented? Crew confers with his lawyer. Marsh whispers urgently. Finally, Crew speaks. Senator, I maintain that my case management practices comply with all applicable rules. Some of these complaints reflect miscommunication or misunderstanding of judicial discretion. Did you read Terrence Williams's motion for new trial before denying it? Silence. Judge Crew, that's a yes or no question. Did you read the motion? I reviewed the relevant portions. The hospital records were 5 pages. The legal memorandum was 12 pages. Total 17 pages. Did you read all 17 pages before ruling? Crew's jaw tightens. I reviewed sufficient material to make an informed decision. That's not what I asked. Yes or no, did you read the complete motion? Senator, judicial efficiency sometimes requires yes or no. The silence stretches. Crew realizes he's trapped. Admitting he didn't read it confirms negligence. Claiming he did makes him a liar in front of Senate committee and cameras. There's no good answer. I don't recall the specific details of every filing from 2018. You don't recall whether you read a motion that resulted in an innocent man staying in prison 8 extra months? Crew's lawyer stands. Mr. Chairman, I object to this line of questioning. Senator Holloway is badgering the witness. This is a confirmation hearing, Mr. Marsh, not a trial. Wilcox's voice is sharp. The senator is entitled to ask pointed questions about judicial conduct. Judge Crew, please answer. Crew's hands are shaking now. Visible tremor, worse than when he first recognized Marcus. To the best of my recollection, I reviewed the motion and determined it lacked merit. Based on what analysis? Your two-sentence denial didn't cite any legal authority, didn't address the alibi evidence, didn't explain why the hospital records were insufficient. What was your reasoning? The defendant had already been through trial, and the new evidence standard is very high. 28 U.S.C. Section 2255 requires an evidentiary hearing when material facts are disputed. Hospital records proving alibi are material facts. You were required by statute to hold a hearing. You didn't. Why? No answer. Crew just sits there, the weight of 7 years of negligence collapsing around him. Marcus slides forward his final exhibit. Mr. Chairman, this is my personal internship evaluation from August 2018, signed by Judge Crew. Quote, Mr. Holloway's work was adequate, but he demonstrated concerning patterns of insubordination and inability to accept constructive criticism. I cannot in good conscience provide a positive recommendation for bar admission. He reads it calmly, professionally, but the words sting even now. 7 years later, they still carry power. I received a neutral letter, no recommendation. It nearly destroyed my law school applications. I got into Ohio State on scholarship because Professor Alan Cho saw my work and advocated for me despite the letter. But that neutral recommendation followed me. Clerkship applications rejected, job offers withdrawn, every opportunity requiring explanation of why my internship supervisor wouldn't vouch for me. Marcus looks directly at Crew. You tried to end my career before it started because I witnessed your negligence and documented it. You've done this to 9 interns that we know of. You've been reversed by appellate courts 41 times. You've kept innocent people in prison because you couldn't be bothered to read their motions. And the system protected you at every step. Court administration buried complaints, chief judges enabled you, judicial councils issued meaningless coaching. He closes his folder. I'm not asking you to withdraw your nomination, Judge Crew. I'm telling you, this committee should reject it. You don't deserve promotion. You deserve investigation by the Department of Justice for deprivation of civil rights under color of law. You deserve disbarment. You deserve to face the consequences that should have come 7 years ago when I filed that complaint and the system failed. The hearing room erupts. Reporters rushing for exits to file stories. Senators conferring urgently with staff. Chairman Wilcox banging gavel for order. But the chaos has its own momentum now. Crew sits frozen. His lawyer is packing their briefcases, damage control mode, calculating how to minimize fallout. But there's no minimizing this. The hearing was broadcast live. C-SPAN captured everything. Within an hour, clips will be on every news site. By evening, cable news will have legal experts analyzing the testimony. Judge Dalton Crew's career, 19 years of federal service, lifetime appointment, presumed promotion to appellate court, is over. Marcus stands. Mr. Chairman, I move that this committee postpone its vote pending further investigation by the Department of Justice and the Judicial Conduct Commission. So moved, Wilcox says immediately. This hearing is adjourned. Gavel falls. Final. Absolute. Among. Outside the Russell Building, media circus. 20 cameras, 30 reporters, microphones thrust forward as Marcus exits with his chief of staff, Kim Delgado. Senator Holloway, how long have you been planning this? Senator, are you calling for Judge Crew's impeachment? Senator, will you pursue charges against Chief Judge Bellamy? Marcus stops at the microphones. Kim had advised him to walk past, let the testimony speak for itself. But Marcus has learned something in 7 years. Silence is how systems perpetuate. Speaking is how they break. I've been documenting Judge Crew's conduct since July 2018. I kept every note, every case citation, every complaint I filed and saw buried. I did this because I still believe, that evidence matters, that truth matters, that accountability has to exist even when it's delayed. Reporter shouts, "Are you pursuing this because of personal grievance?" I'm pursuing this because Terrence Williams spent 8 extra months in prison for no reason. Because interns are still being abused in federal chambers with no recourse. Because the system that's supposed to ensure judicial integrity is protecting misconduct instead of stopping it. Another reporter. What happens next? The Senate Judiciary Committee will postpone the confirmation vote. The Department of Justice will review the testimony for potential civil rights violations. The Judicial Conduct Commission will reopen their investigation with new evidence. And Chief Judge Bellamy will have to answer for why he buried complaints instead of investigating them. Will Judge Crew be removed from the bench? That's for the Judicial Council to decide. But he won't be promoted, and the pattern of negligence will be on record permanently. Marcus steps away from the microphones. Kim guides him toward the waiting car. But before he gets in, someone calls his name. Senator Holloway. He turns. Terrence Williams, standing at the edge of the media scrum, eyes wet. Thank you. Thank you for... His voice breaks. Nobody ever listened before. Nobody cared that I was innocent. Thank you for making them listen. Marcus crosses to him, shakes his hand. You made them listen. You were willing to testify. That took courage. You gave me the platform. You built the case. You... Terrence stops, composes himself. You could have let it go. Moved on. You're a senator now. You didn't need to do this. Yes, I did. Marcus means it. Because if I didn't, he'd keep doing it. And the next intern, the next defendant, the next person without power, they'd suffer the same way we did. They stand there for a moment, two men connected by shared experience of institutional failure, now witnessing the beginning, just the beginning, of accountability. Terrence nods, walks away. Marcus gets in the car. Kim hands him her phone. You need to see this. It's already trending. Crew hearing. Judicial accountability. Clips of Marcus reading the complaints, Terrence testifying, Crew's stammering non-answers. The internet is doing what the internet does, amplifying, dissecting, making viral the moment when power faced consequence. DOJ wants to meet tomorrow, Kim says. Judicial Conduct Commission is expediting their investigation, and, she hesitates, Chief Judge Bellamy announced his retirement, effective immediately. Marcus looks up. That was fast. Probably advised by counsel, get out before he's forced out, preserve his pension. It's how these things work. The truly powerful find escape hatches, leave before consequences arrive. But at least he's gone. At least he can't bury more complaints. What about the interns? Marcus asks. The ones who filed complaints and never got justice? We're reaching out, offering to connect them with attorneys if they want to pursue civil claims. Some will, some won't. It's been years. They've moved on. But at least now they'll know the system acknowledges they were right. The car drives toward Marcus's office. He stares out the window at Washington, D.C., monuments to justice, marble buildings proclaiming ideals, a city built on principles that are constantly tested and often fail. 7 years. From intern to senator. From powerless to powerful. From victim to, not victor, because victory implies the fight is over. Witness, maybe. Architect of accountability. Builder of the case that finally worked. His phone buzzes. Text from his mother. Watched the whole thing, so proud. Your father would be too. His father, dead when Marcus was 15, never lived to see his son become the first in the family to finish college, let alone become a senator. But Marcus likes to think he'd understand this moment. The long preparation, the patience, the documentation that turned suffering into evidence. He types back, "Love you, Mom. Coming home this weekend. Let's celebrate." Another text, this one from Professor Alan Cho, the law school professor who'd believed in Marcus despite the neutral letter. You built a case 7 years long. Masterful work. Let me buy you dinner next time you're in Columbus. Marcus smiles, puts the phone away. Don't miss the conclusion. Subscribe now, because the systemic changes Marcus is about to trigger will shock you. April 3rd, 2025. Senate floor. Confirmation vote on Judge Dalton Crew's nomination to the 6th Circuit Court of Appeals. Except it's not a vote, it's a withdrawal. Senate Majority Leader takes the podium. Judge Crew has requested his nomination be withdrawn. The White House has honored that request. No vote will be held. Crew withdrew after his attorneys reviewed the DOJ preliminary findings and recommended he resign from the bench entirely rather than face formal investigation. He declined resignation, lifetime appointment, he can't be forced out without impeachment, but agreed to take senior status. Reduced caseload, administrative duties only, no more presiding over criminal trials where his negligence could imprison innocent people. It's not justice, but it's consequence. More consequence than the system usually delivers. The Senate moves on to other business. But Marcus stays on the floor, watching the procedural ballet, thinking about what comes next. Because the hearing didn't just stop one promotion, it cracked something larger. April 15, 2025. Sixth Circuit Judicial Council issues formal findings from expedited investigation. Investigation into complaints regarding Honorable Dalton Crew. Findings: pattern of procedural shortcuts spanning 12 years, inadequate case review, hostile work environment for interns and staff, multiple violations of Code of Conduct for U.S. judges, Canon 3, duty to perform judicial duties fairly without bias or prejudice. Recommended sanctions: formal censure, reassignment to senior status, mandatory judicial ethics training, chambers operations subject to administrative oversight for 18 months, all pending cases reviewed for potential procedural deficiencies. Censure: public record, permanent stain on Crew's reputation. Future law students will read about him in judicial ethics textbooks, the cautionary tale, the example of what happens when efficiency overrides justice. April through June 2025. Appellate courts begin systematic review. 41 cases reversed under Crew, but hundreds more potentially affected. Defendants start filing motions for reconsideration based on new evidence of judicial negligence. 6 cases granted. Terrence Williams, already exonerated, now officially pardoned. Record expunged. David Munoz, armed robbery, served 12 years. New trial ordered. Prosecution reviews evidence, declines to retry. Released May 2025. Innocent. Angela Foster, drug conspiracy, served 8 years. Conviction vacated on procedural grounds. Released June 2025. 3 others, various charges, various sentences, all getting second chances they should have had the first time. But 11 defendants, already served full sentences, released years ago. Can't undo the time stolen, can't give back the years. Civil settlements offered, money paid, but money doesn't restore time. Marcus knows this, knows that accountability isn't the same as justice, that consequence isn't the same as repair, but it's progress. It's more than existed before. Tight. June 2025. Marcus introduces legislation. Judicial Accountability and Transparency Act, co-sponsored by bipartisan coalition, unusual in polarized Senate, but judicial reform has support across ideological lines when the evidence is this clear. Key provisions. 1. Mandatory reversal rate reporting. All federal judges, district and appellate, required to publish annual statistics on cases reversed, reasons for reversal, comparative data against peers. Public database, searchable, transparent. 2. Independent intern complaint review. Complaints no longer handled by court administration. New independent panel, 3 attorneys, 2 former interns, 1 judge from different circuit. Real investigation required. No more coaching closures. 3. Judicial ethics training. Mandatory biennial training on case management, due process requirements, workplace conduct, not optional. Not perfunctory, substantive. 4. Appellate authority to reassign cases. When judges' reversal rate exceeds circuit average by more than 200% for 2 consecutive years, appellate court can reassign pending cases and mandate additional oversight. 5. Whistleblower protection. Interns, clerks, and court staff who report misconduct through proper channels receive protection from retaliation. Neutral recommendation letters become grounds for investigation. The bill passes committee. Narrow vote, 12-10. Heads to Senate floor. Outcome uncertain. Republicans worry about judicial independence. Democrats worry about executive branch overreach. Everyone agrees something needs to change, but legislating that change requires threading needles, balancing competing interests, compromising on details. Marcus knows it'll be diluted, amended, some provisions stripped, others weakened. But foundation will remain. Transparency, accountability, protection for whistleblowers. Better than nothing. Better than silence. July 2025. Marcus receives letter. Handwritten. Postmarked Columbus. He opens it in his Senate office, late evening, staff gone home. The handwriting is shaky, older person, or someone nervous. Senator Holloway, I watched you testify against Judge Crew. I should have done that 7 years ago when you filed your complaint. I was Judge Crew's courtroom deputy. I saw everything, the files in trash, the rulings without review, the way he treated interns. I stayed silent because I was afraid. Mortgage, kids in college, pension 5 years away. I chose security over integrity. I'm sorry. I retired last month. I'm free now. If you need testimony for your legislation, or if DOJ needs witnesses, call me. I'll tell the truth. Better late than never. Claudette Rains. Marcus reads it twice. Remembers Claudette, always present, always watching, never speaking. The guilt she must have carried, watching abuse and staying silent because the system punished integrity and rewarded complicity. He calls her, thanks her, asks if she'll testify at the next Judiciary Committee hearing on the reform bill. She agrees immediately, voice thick with relief and residual shame. One more ally, one more voice. The coalition building slowly, witness by witness, testimony by testimony. System changes slowly, but it changes. August 2025. Marcus is reviewing briefing materials when Kim walks in with urgent expression. We have a problem, or maybe an opportunity, depends how we handle it. She hands him a document. PDF, marked confidential, attorney-client privilege header. How did you get this? Anonymous email, sent from burner account, untraceable. Marcus reads, Court Administration Memo, dated 2016, from Vivian Shaw to Chief Judge Bellamy. Third complaint this year from Crew's chambers. Recommend formal investigation per judicial conduct rules. However, Judge Crew has expressed concerns that investigation would damage district reputation and create chilling effect on judicial efficiency. Advise we resolve through informal coaching. Preserves institutional harmony. Bellamy's handwritten response. Agreed. Close file. No further action needed. This is the smoking gun. Not just knowledge of complaints, active decision to bury them. Chief Judge explicitly choosing institutional reputation over accountability. Bellamy retired, Marcus says. He's gone. But Vivian Shaw isn't. She's still court administrator, still in position to bury complaints, still controlling the same systems that failed. Marcus stares at the memo. Evidence of conspiracy. Proof that the failure wasn't accidental, wasn't bureaucratic incompetence. It was choice, deliberate, calculated choice to protect a judge over protecting justice. What do we do with this? Kim asks. Marcus considers. He could release it publicly, fuel the story, keep momentum going, force Shaw's resignation. But that might poison the legislative effort, make it too partisan, give opponents ammunition to claim this is vendetta rather than reform. Or he could hold it, use it strategically, present it at the right moment when opposition to the bill crystallizes, when evidence of systemic failure is needed to break logjam. We keep it, he decides, for now, but we verify it, metadata, chain of custody, authentication. When the moment's right, we use it. Kim nods. And if that moment doesn't come? Then we release it anyway, just later. Because Shaw deserves consequence too. Everyone who enabled this deserves consequence. The memo goes in a folder, marked pending, waiting for the right moment. Some threads don't close immediately. They wait, patient, documented, ready. Chautauqua. September 2025. Judicial Accountability Act comes to Senate floor. Debate scheduled for 3 days. Marcus gives opening remarks, not about Judge Cruz specifically, but about systemic patterns, about the need for transparency, about protecting both judicial independence and judicial accountability. The opposition arguments are predictable. This bill threatens judicial discretion, creates chilling effect on case management, opens floodgates for frivolous complaints. Republican senators, particularly those with strong law and order credentials, resist anything that looks like judge oversight. But Marcus has allies. Senator Yates, Georgia Republican who questioned him during the hearing, introduces amendments strengthening whistleblower protections. Signals shift in Republican caucus, recognition that this isn't partisan attack, but institutional necessity. Day 2 of debate, Marcus introduces the Shaw memo, reads it on the floor. Every word, every implication. This memo proves that complaint burial wasn't accidental. Chief judges and court administrators made deliberate decisions to prioritize reputation over accountability. My bill creates independent oversight precisely because internal systems failed. Not occasionally. Systematically. The memo shifts momentum. Moderate Republicans, already uncomfortable voting against judicial reform, can't defend active cover-up. Democrats, energized by evidence of institutional corruption, push hard for passage. Day 3. Vote, 58 hours to 42. Bill passes. Not as strong as Marcus wanted. Amendments weakened some provisions, delayed implementation timelines, added carve-outs for certain types of cases. But the core remains. Transparency, independent complaints review, mandatory training, protection for whistleblowers. President signs it October 1st, 2025. Rose Garden ceremony. Marcus is there, standing behind the president, watching his legislation become law. 7 years, 2 months, 8 days since he left Judge Cruz's chambers with 3 notebooks and a destroyed future. Now, law, reform, change codified into federal statute. Not victory, because the fight isn't over, because implementation will be battle, because entrenched interests will resist at every step. But progress, real, measurable, documented progress. November 2025. Marcus returns to Columbus for Thanksgiving, first time back since the hearing. He drives past the federal courthouse, same marble columns, same imposing facade, but different now. Crew on senior status, barely visible. Bellamy retired. Shaw demoted, transferred to different district. New chief judge appointed. Judge Amara Okafor, first black woman to hold position in Southern District of Ohio. Her first action? Implement intern complaint reform 6 months ahead of federal mandate. Independent review panel. Transparent reporting. Zero tolerance for retaliation. Marcus doesn't visit. Doesn't need to. The building that once represented his trauma now represents something else. Proof that institutions can change when forced, that accountability can exist when evidence is overwhelming, that patience and documentation and strategic positioning matter. He drives to his mother's house. She's cooking. Turkey, dressing, collard greens, sweet potato pie. His childhood home, smaller than he remembers, walls covered with photos. Marcus at high school graduation, college graduation, law school, swearing in as state senator, swearing in as U.S. senator. His mother hugs him, holds on longer than usual. "You did it," she says. "You really did it. We did it. You taught me to document. You taught me patience. You taught me that evidence matters more than anger. I taught you to survive. You figured out how to fight." They eat dinner. Talk about family, holidays, plans for Christmas. Normal life, the kind Marcus rarely experiences anymore. Senate schedule is brutal. 18-hour days, constant travel, endless demands on time and attention. But tonight, he's just her son. Eating turkey, watching football, being present. His phone buzzes. Text from Terrence Williams. "Happy Thanksgiving, Senator. Grateful for you every day. Got accepted to paralegal program at Columbus State, starting in January. Going to help other people like me. Marcus smiles. Texts back. Proud of you. Let me know if you need recommendation letter. I write good ones. Another text, this from Dr. Lorna Pierce. The intern program reformed completely. New oversight. Real accountability. Thank you for forcing change. Then, Jessica Ortiz, his fellow intern from 2018. Saw your interview on CNN. You're making a difference. Keep going. One by one, messages from people whose lives intersected his during that summer, whose experiences of institutional failure connected them, who witnessed Marcus transform suffering into evidence and evidence into law. He puts the phone away. His mother notices. Everyone thanking you? Something like that. You deserve it, but don't let it go to your head. Pride comes before the fall, and you've got work left to do. Marcus laughs. Always the realist. Always your mother. She cuts him another slice of pie. Now eat. You're too thin. Senate feeding you properly? Normal mom concerns. Normal life. The kind of grounding Marcus needs to stay human, to remember why he fights, to avoid becoming the thing he opposed, someone who cares more about power than people. December 2025. Year ending. Marcus reflecting. 7 years ago, intern, powerless, destroyed by system that protected abuse. Today, senator, lawmaker, architect of reform that will protect future interns from suffering the same way. The journey wasn't direct, wasn't easy. Required surviving law school with neutral letter, working for legal aid representing defendants trapped in same system, running for state legislature on judicial reform platform, building credibility and relationships and political capital until the moment came, until Crew was nominated and Marcus had position to make evidence matter. Long game. Longer than most people have patience for. But patience is power when you're documenting. When every day of waiting adds evidence to the pile. When you're building case that can't be ignored. Marcus opens his desk drawer. 3 notebooks, original documentation from 2018. He hasn't looked at them in years. Doesn't need to. Contents memorized. But seeing them again, physical evidence of that summer, reminds him of the stakes. Every page represents suffering. Every entry represents injustice. Every timestamp represents a moment when the system chose power over accountability. But also, every page represents preparation. Every entry represents evidence that eventually mattered. Every timestamp represents proof that documentation is power when the moment comes. He closes the notebooks, returns them to the drawer. The case is closed. Judge Crew censured. Chief Judge Bellamy retired. Vivian Shaw demoted. Reform legislation passed. Systemic changes implemented. But other cases wait. Other judges operate with impunity. Other interns suffer in silence. The system is larger than one district, one judge, one summer of abuse. Marcus's work isn't finished. It's just beginning. January 2026. New session of Congress. Marcus returns to Washington, D.C. Committee assignments announced, remaining on judiciary, added to appropriations. More power, more platform, more opportunity to drive reform. First hearing of new session. Oversight of federal judicial administration. Marcus chairs. He's prepared extensively. Documentation from multiple districts, complaints from dozens of interns, reversal rate data showing patterns across circuits. The Crew case was one example, but examples are plural. This committee will examine systemic patterns of judicial misconduct and administrative failure to address complaints. We have witnesses from 7 federal districts. We have documentation spanning 15 years. This is not isolated incident. This is institutional problem requiring institutional solution. The hearing unfolds over 2 days. Witnesses testify, former interns, exonerated defendants, whistleblowers who were retaliated against. Each testimony adds weight to the case that reform must expand beyond what the first bill accomplished. Day 2, surprise witness. Someone Marcus didn't expect. Preston Gaines, former senior law clerk from Judge Crew's chambers, the man who'd enabled the abuse, who'd warned Marcus not to make waves, who'd protected Crew's reputation at the cost of Intern's dignity. Preston approaches the witness table. He looks different, older, worn, burdened by something Marcus recognizes: guilt. "Mr. Gaines, thank you for agreeing to testify. Please state your relationship to Judge Crew." "I was his senior law clerk from 2015 to 2022. I managed chambers operations, supervised interns, handled case assignments." "Did you witness the conduct described in the complaints filed by Senator Holloway and others?" Preston pauses, breathes. "Yes, I witnessed all of it." "Did you report it?" "No." "Why not?" "Because Judge Crew was my employer. He controlled my career prospects. A good recommendation from him meant clerkship opportunities, prestigious firm positions, judicial appointments. A bad recommendation meant—" He stops. "It meant my career would be limited, so I stayed silent. I enabled. I participated." His honesty is shocking. Witnesses usually hedge, minimize their culpability. Preston is doing the opposite, confessing, accepting responsibility, acknowledging harm. "What made you decide to testify now?" "I watched Senator Holloway's testimony in March, watched Judge Crew sit there and lie, watched the system almost let him get promoted despite everything, and I realized my silence made me complicit. My career advancement came at the cost of other people's suffering. I can't undo that, but I can tell the truth now." Marcus leans forward. "What truth do you want to tell?" Judge Crew's conduct wasn't secret. Everyone in chambers knew. Everyone in court administration knew. Chief judges knew. Judicial councils knew. The system didn't fail by accident. It failed by design. Because protecting judges is more important than protecting justice. His testimony continues for 40 minutes. Details about how complaints were pre-screened before reaching official channels. How court administrators coached judges on avoiding formal censure. How judicial councils closed investigations without interviewing witnesses. Systemic failure. Deliberate, calculated, institutional. When Preston finishes, Marcus thanks him. "Mr. Gaines, coming forward takes courage, especially when you're admitting your own culpability. Why risk it?" "Because Senator Holloway was right. Documentation matters. Truth matters. And if people like me, people who benefited from the system, don't speak up, nothing changes. I want to be part of the change, even if I was part of the problem." He steps down. Marcus watches him go, thinking about redemption, about how people can choose differently even after years of choosing wrong, about how movements need truth-tellers from inside systems to break institutional silence. The hearing concludes. Transcripts will be published. Evidence will be compiled. More legislation will be drafted. Stronger oversight, clearer accountability mechanisms, harsher penalties for retaliation. The work continues. February 2026. Marcus is in his office when Kim brings news. Vivian Shaw resigned, effective immediately. Marcus looks up from the briefing papers he's reviewing. Why now? DOJ investigation concluded. Found evidence of systematic complaint suppression. Offered her choice, resign with pension or face charges for obstruction of justice. She chose resignation. Another consequence, another piece of accountability. Not justice. Shaw gets to retire comfortably, keeps her pension, avoids criminal record. But she's gone. Can't bury more complaints. Can't protect more abusers. Who's replacing her? Interim administrator is Ellen Wu, former civil rights attorney. Strong record on transparency and accountability. If she's confirmed permanently, it'll be a significant upgrade. Progress. Incremental, insufficient, but real. Marcus returns to his papers. The next fight is always waiting. The next reform to draft. The next hearing to prepare. The work of building accountability is never finished because systems are designed to resist it, to revert to protection of power unless constantly pressured toward justice. But Marcus knows patience. knows documentation, knows that small victories accumulate into larger change if you stay focused, stay strategic, stay committed. 7 years from intern to senator. How long from senator to what? Appellate judge? Supreme Court? Attorney General? He doesn't know yet, doesn't need to know. The path reveals itself one step at a time when you're building towards something larger than personal advancement. Right now, judicial reform. Making sure the system that tried to destroy him doesn't destroy others. Making sure the evidence that saved him becomes the foundation for protecting people who can't protect themselves yet. Later, whatever comes next. Whatever position gives him the most leverage to continue fighting, the most platform to amplify truth, the most power to implement accountability. But always, documentation, evidence. Truth spoken when speaking costs something, when silence would be easier, when staying quiet would preserve comfort. Marcus learned that lesson in a courthouse in 2018. 3 notebooks, 400 pages, 7 years of preparation. He's still learning it, still documenting, still building cases that won't be heard for years but will matter when the moment comes. The fight isn't over. It's never over. But every day, the system bends a little closer toward justice. Every testimony adds weight. Every reform creates space for the next reform. Marcus thinks about the interns who'll come after him, the ones who'll work in federal chambers redesigned by his legislation, who'll have protection he didn't have, who'll be able to speak up without destroying their futures. They won't know his name, probably, won't know the story of how the protections came to exist. Will take for granted the oversight and accountability that required 7 years of strategic patience to build. That's fine. That's how progress works. Current generation suffers, so the next generation doesn't have to. Evidence collected in silence becomes foundation for changes that future people inherit as normal. Marcus closes his briefing folder, looks at his calendar. Hearings, votes, meetings, constituent events. The machinery of Senate life, but also purpose, direction. The knowledge that he's building something that extends beyond his own career, beyond his own pain, beyond the personal grievance that almost consumed him in 2018. Justice delayed isn't justice denied when you're patient enough to wait for the moment when evidence becomes power. Marcus Holloway, former intern, current senator, future architect of whatever comes next, is patient. And he's still documenting. The case is never closed. It just enters new phases, new hearings, new opportunities to speak truth in rooms where power is forced to listen. 7 years ago, he walked down courthouse steps carrying 3 notebooks and the belief that truth matters. Today, he sits in the U.S. Senate, having proved that belief correct. Tomorrow, who knows? But whatever it is, Marcus will be ready, because he's been documenting the whole time.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.